Hey everybody, today's lesson is going to be about civil law. We know that there's two different laws, civil and criminal law, okay? And today we're going to do the one dealing with civil law. So when you think of civil, it's somebody suing somebody else, not somebody committing an act of crime against the state. Um, so over 90% of state court cases anyhow, are civil law. So the majority of them that you're going to see in the state are going to be civil, although there are many forms of criminal misdemeanors and different acts of law when it comes to that. But the four important types of civil law include contracts, property, family relations, and torts. Okay, civil injuries to a person or property. So you walk outside, your neighbor's dog trips you, bites your arm, and you sue them for medical damages. That's called a tort. Family relationships. We see these all the time. In the States, they even have specific marriage courts, divorce courts, and child custody courts that you will specifically go to if you happen to engage in one of these three issues, okay? The other one going up from the bottom, property, the use and ownership of real property, home, land, anything on it, and personal property, car, clothes, stocks, even, okay? Suing over any damages to those or anything along those lines. And then last but not least, contracts. Voluntary promises enforced by the law. I think we see the majority of being divorce. Going back to family relations, kind of that's a contract as well through the state. So when you get a divorce, splitting everything, figuring out custody. Bad credit, bankruptcy, okay, which is a federal crime. Jobs, dealing with suing your job. Cars, or any kind of mortgage company that violates their contracts, okay? And that's what that one's about. So any of these can be civil. Majority of them are. Steps in a civil case, lawsuits. You're going to watch an episode of Judge Judy here, and you're going to see two different things. You're going to see a plaintiff, and you're going to see a defendant. A plaintiff is the one who brings the charges in a lawsuit, called the complaint. They will be the one that's going to usually give their case first on why they brought the case here. The defendant is the person the plaintiff is bringing suit against. All right. If the plaintiff wins, the defendant usually will pay damages and the court costs that the plaintiff had, so they'll get everything paid for. If the defendant wins, the plaintiff must pay all the court costs, and of course, the wins nothing. Okay, so you get a little both sides of it. Injunction is a court order that forbids a defendant from continuing an act. For instance, a building's polluting, may cause health effects, shutting, the judge may shut or injunct that building to be shut down. Some procedures when it comes to a civil court case involves, much like a criminal one, hiring a lawyer, filing a claim, which is not in the criminal one, but a pre-trial discovery, a resolution without trial may happen. If that doesn't happen, a trial, and then obviously the reward is going to be given to the plaintiff or the defendant. When you go to hire a lawyer, whether you're a plaintiff or a defendant, lawyers will generally work for what we call a contingency fee. They'll usually work if they want. If you're suing a doctor's office or a medical establishment or a school, sometimes if they see big money signs in front of it and they have a good chance to win, they won't work for hourly fees. Sorry, they will work for 1/5 to 1/2 of the winnings. So if they see you being able to win $3 million, they'll work for maybe half the winnings for $1.5 million, and it's all based on commission. They either get it or they don't. If you do lose, they might have in the contract where you pay them an hourly fee for their work. So if the lawyer gets nothing if the case is lost, or they will make an hourly wage but no winnings. The plaintiff pays for copying fees and costs for interviewing experts that they do. When the plaintiff files a complaint, which is a legal document filed within the court that has jurisdiction within that court system. Okay, so if you're suing somebody within Erie County, you're going to go or in this locale, you might go see Denise Stuck-Lewis, who's our district magistrate, represents this district in this area. The complaint explains what the defendant did wrong, allowing the defendant to mount a defense. When you file the complaint with the courts, then there will be a summons. After the complaint, the defendant will receive a document stating the date, time, and place to appear in court. They can either dismiss or answer it. The defendant then must file an answer to the court to either end the case, dismiss it, or answer a formal response to the charge. Okay, so one of two things. After that happens and they're summoned, There could be a pretrial. There's going to be a pretrial discovery. Both sides will then check facts and gather evidence against the case, involving interviews, photos, witnesses. May be very time-consuming and expensive, unless you do it by yourself, which many of the Judge Judy people that go in there kind of do it by themselves. They try to research documents and phone records. This can take months or even years in specific major cases against businesses, schools, so on and so forth. Resolution without a trial. Now, not all of them go to trial. In pretrial discovery, some of them will settle for what we call a plea bargain. 90% of all cases are settled even before they get to trial to not deal with all of the issues of going to trial. There's mediation, okay, which is a mediator. And in between that hears both sides, creates a fair settlement for both, what they believe it is. Or we can go through arbitration, which is a professional who decides on a settlement or all possible answers. So basically, if you're going through arbitration, they're going to spit at you like, hey, here's what's gonna happen. Here's what's gonna be offered. You guys can either take it or leave it. This is what we believe should happen. So whether it's leaning towards one side or not, that's known as arbitration. Settlements happens because each side will begin to build up costs, causing both sides to meet and settle on a fair agreement. So if it gets a little over both sides' head, they will try to settle, or plea bargain is another word for it. Pretrial conference, called by the judge to talk things over. Then the courts can require cases to be settled outside of the court if need be. If they can't decide on a settlement or arbitration or a mediator or mediation involving the court case, it will go to a trial, as we like to call it. These cases may be heard by one judge and a jury of 6 to 12 people. The plaintiff, the person accusing the defendant of the crime, starts and gives their side, followed by the defendant. Both sides will give a summary of their cases, then the judge or jury renders the verdict. So if it's under, like we said in the amendments, usually if it's under 5,000, we'll just have a magistrate sitting there, a judge sitting there like Judge Judy, and there will be no jury trial. If it's over that amount, you can request a jury trial, and then the jury will decide. The judge will rule. The jury will decide. If not, the judge will decide. The award must be given, okay? Maybe more or less than the plaintiff actually wanted. A judge can modify a jury's awards if they believe the award is out of line. For example, McDonald's coffee case. Do you guys all remember when there was no hot warning sign around the coffee mug at McDonald's and the lady spilled it on her, got third-degree burns because the coffee was too hot? She sued McDonald's because she was not aware that the coffee was hot, obviously, supposedly. She won $2.7 million, or he, not really sure if it was a he or she, and the judge modified that award to $640,000. Still not a bad payout for getting yourself burned by a cup of coffee. I'd probably take that one. If the defendant refuses to pay, the defendant can get a court order, and the court can start seizing property, taking money from a paycheck or an account that person has. Last but not least, a small claims court. This is like Judge Judy. Most court cases that are suing people or going for civil will be settled in small claims courts. We have small claims courts specifically in the state of Pennsylvania and other states as well. There's no lawyers that are necessary because judges end up deciding the case. There is a fee for filing a claim, which are usually around pretty cheap, $10 to $15. The defendant then has 2 to 4 weeks to respond to the date that is set. Claims range from $1,000 to $5,000. Like I said, anything over $5,000, you can request a jury trial. You still don't need a jury trial. You can request it and get it. That's in our amendments. We know that. The plaintiff usually shows evidence or a sworn statement from a person that was there, a witness. If the defendant fails to appear, the plaintiff usually wins the case. Payments can take a while, and the court orders a payment may be handed over to the sheriff's department. What we're going to do now is you have a Judge Judy Q&A, and I'm going to expect you to watch the episode on Schoology on Judge Judy on YouTube, and one episode, and you're going to answer the questions on the Judge Judy worksheet. It's going to talk about the plaintiff, the defendant, what's the case, what's the kind of the proceedings, what's the ending, what's the reward, okay? And you guys will just kind of go over and review what we just did, and you'll be able to see it firsthand and see how Judge Judy actually does it. All right, guys, have a great day. This is civil court. Next week, we were going to talk about criminal court cases, and we're going to do a little project on that, which I think you guys will like, and it will be fun. All right, don't forget, watch Judge Judy and do the Judge Judy Q&A. All right, guys, have a good day.